Hello, everyone, and thank you for coming this afternoon. I'm Brett Crumley, lecturer in the law school at the Open University, and my paper is entitled Chantries and Brass, Unexpected Archives of Legal Charity. So the contents of this talk is based on a paper, a kind of extract from the paper that fits into an unexpected find in an old church. First I'll talk about the dissolution of the monasteries, and then I'll talk about St. Mary Magdalene's Church in Newark-on-Trent, which is the unexpected archive. Then I'll talk about the Magnus bequest, and then I'll draw some conclusions together and talk through the implications of what I have found. I will have to be quite brief on some of the aspects of my talk, just for time, so I can answer further questions in the Q&A at the end if anybody's interested. But hopefully I'll say enough about each element that it all does make sense within 15 minutes. So first, the dissolution of the monasteries. So the dissolution of the monasteries happens during the transition from feudalism to capitalism in England and Wales. And that transition from feudalism, from a feudal mode of production to a capitalist mode of production, required the development of means and forces of production, eventually a centralised state, and a facilitative legal framework. Now, Christopher Hill, in his Reformation to Industrial Revolution, speaks about the need for law to have supported some of the changes that were seen in the economic and political sphere. And so what I'll focus on today is the aspects of that legal framework that came from or were set in the context of what we now call charity law, although at the time they may not have seen the relevant laws as being part of a body of charity law. But I think it's a useful frame because it does connect things together and helps us to see how there are connections with modern law, although I won't go into modern law today. So legal jurisdiction during feudalism was at times a matter of private property. The lords of any particular land or the church would have legal jurisdiction over things that happened within their property, and eventually this was centralized. But during this kind of period of feudal jurisdiction, there was for a time from around the 9th century no legislation, only common law for a couple of hundred years, and then eventually you get statute, which I'll talk about later. Questions of charity, or for example, what kind of pious causes were valid, lay historically with the ecclesiastical courts, who developed a lot of the kind of foundations of modern charity law long before the period of modern charity law begins. And within that context, the judges in the ecclesiastical courts would have been loyal to the Catholic Church, not necessarily to the Crown. Later on, Lord Chancellors sitting in Chancery could attend to the Crown's interests, but that again took a few hundred years to develop, all throughout this transitionary period between feudalism and capitalism. And when I talk about the Crown, and I'll mention the Crown again a few times in the talk, I'm not just talking about the individual person who wears the crown. I'm talking about a loose and sometimes tight-knit collection of groups and interests and persons who kind of, the crown is the kind of center, kind of lightning rod for those interests. And also during this period of transition from feudalism to capitalism, you start to see statutes being enacted which protect the Crown's interests. The statutes I'm going to focus about were enacted under Henry VIII and Edward VI, who enacted various statutes relating to mortmain. Mortmain is a kind of dated concept now, but it's the idea, I mean, it still exists. We just tend not to use that word. Mortmain is the idea that a dead hand grips property and decides what is to be done with that property. So this could be a corporation not being a living mortal human, can decide what happens to property through human actors, but the corporation itself doesn't die, and so it can last forever, theoretically. And also gifts to charitable purposes, pious causes, would be applied to purposes identified by a person who is potentially long since dead. And so the Mortmain Acts, or really their anti-Mortmain Acts, were an attempt to limit the power of making property inalienable by giving it to corporations or setting it aside for purposes which living persons could not alter. So the Mortmain Act of 1531 to 32 banned dispositions of more than 20 years of land to the use of parish churches, chapels, guilds, brotherhoods, and for obits and chantries. Then a few years later, we have the Suppression of Religious Houses Act, 1535, which closed the smallest monasteries and religious houses and seized their property and any property disposed in the previous 12 months before the act commenced. And then another few years later, we have the Dissolution of Monasteries and Abbeys Act, 1539, which consolidated seizures made since 1536, which is the time that the 1535 Act came into effect. Those three were made under Henry VIII, and then Edward VI made or enacted the Act whereby certain chauntries, colleges, free chapels, and the possessions of the same be given to the King's Majesty in 1546. And this transferred all chantries and most colleges and chapels to the Crown. And so this is kind of an important time, because what this process did was take property from the Catholic Church and hand it over to the Crown, or rather the Crown seized it. And also some adventurous towns seized property in the chaos, but I won't talk about that element in this talk today. Keith Wrightson in Earthly Necessities says that this was the greatest land transfer in England and Wales since the Norman conquest. And there are some important kind of implications of the dissolution. It wasn't just this kind of religious dispute. It led to substantial developments that were required for capitalism to develop in England and Wales, such as, although it was incomplete, a move towards centralised power over land, which facilitated a centralised state formation. And it created the conditions, because land that was taken through the dissolution was then given to supporters of the Crown, and who then sold it on or kept it. Land that had long been set aside for certain purposes or to certain corporations, religious corporations, were freed from those old encumbrances, and this allowed long-term investments in agriculture to be put in place, which allowed for a synthesis of agricultural commodity production, i.e. capitalist agriculture, which was not possible under feudal agricultural relations. And in terms of charity, the dissolution shaped the law relating to what gifts would fail for being superstitious and violating Mortmain. St. Mary Magdalene's is a lovely old church in Newark. That's a picture of it from the front of Brenda Pask's book on the church, which looks through the history of it. It was built in between the 12th and 15th centuries, with some additions made in the 16th. There is an old, it was the site of an old pre-1066 church, which has long since disappeared, and updates continue. So it's kind of an eternal project, and they've started work on a new roof this year. Now, the curious thing is that there are two chantries inside, and I went for a visit I was in Newark, so I walked around the church in the summer, and I saw a plaque, which is on the next slide, which referred to chantries, and I thought, oh, that's interesting. Those things should have disappeared a long time ago. And so a chantry, just to be clear, was a place for priests to say prayers to the founder, usually for their soul, so that they would speed through purgatory faster than if prayers were not said, which is, Catholic belief, and the Protestants didn't have the same belief, so the chantries were unnecessary and superstitious. So it's also a type of gift, often of land, that generates an income to maintain the chantry priests. So you don't just build the little chapel, you also attach land with sheep or farming going on, and then the priest gets to eat the lamb or the milk or the grain that's grown. And they were, even in medieval England and Wales, quite a rare sight. In Louth, Nottingham and Mansfield, which are nearby Newark, they only had one each. Newark in St Mary's had 18. They didn't all coexist at the same time, it had 18. And they're also curious because they're supposed not to exist anymore, because they were dissolved, and because they were made out of such valuable materials. You'll see a couple of chantries in the next slides, how ornate and valuable they may have been. The building materials were taken apart and used elsewhere. So here's Fleming's brass, which mentions the chantry that Alan Fleming, a sheep merchant and wool merchant, created, so that the brass commemorates Fleming, and his chantry that he set up is now gone, but the brass is still there as a reminder of what was there. And then here is the Merring Chantry Chapel. Thomas Merring also left, he was also a wool merchant, and he left wool and sheep that was to be sold to build this rather impressive chantry. There's a small chapel inside the church, and you can see the family crests around the bottom of it. And he also left tenements, the income of which was to support the priests who would say prayers for various souls, for various persons after they died. The Markham Chantry Chapel is on the other side of the church. And again, you can see the family crests around the bottom. They kind of mirror images in some respects, but there are important differences. Now, we know slightly less about this one, but the interesting thing is that it still exists. Now, here's a picture of the Magnus School on, I think, Appleton Gate, which is in Newark. Now, there are references to Magnus in Brenda Pask's book and in the church. And the curious thing is that Magnus signed a deed in 1532, which left about 2,000 acres to St Mary's and a school, which was then worth £40 a year. And the last time it was adjusted to see how much it was worth in 1964, it brought an income of around £3,000 a year, or that's what £40 a year would have been worth in 1964. Now, if you remember from a few slides ago, this was the year of the Mortmain Act, 1531 to 32. So how did Magnus create a gift of land during the dissolution that still survives, given the changes to the Mortmain rules? And it turns out that Magnus must have been very well informed, with a good legal team, who foresaw that a testamentary gift might be voided by the Mortmain Act 1532. And Magnus initially planned to leave all this property in his will. When this act was being debated, his lawyers noticed that if he tried to leave this property in his will, it would postdate the act and it would be void. And so he made an inter vivos gift to the church in February 1532, a month before the Mortmain Act 1532 commenced. And the other curious thing is, if you remember earlier, I mentioned corporations, which were also captured by the Mortmain restrictions. And Magnus thought that if he gave property to corporations, they might be dissolved. And in fact, all the corporations that he might have given the property to at the time did dissolve. So instead, he gave the property to 23 private persons. And when their number reduced to 6, at least, they were to appoint more, up to a maximum of 20, so that the property would always be in the hands of alive persons. And what this does illustrates, I think, the creativity of legal drafters and the endurance of legal charity. So I'll try to wrap up some conclusions very briefly. The chantries and the ongoing relevance of Magnus' bequest say something about the endurance of charitable institutions and the place of charity in the origin of capitalism. It's not often put into the story of the origin of capitalism, but during this transition from feudalism to capitalism, there was a need to free land from feudal relations, and the statutes that did that were Mortmain statutes, which had an impact on the way that testators or founders would set up their charities, which some of which still exist today and can still be seen in old churches, for example. And it's kind of a testament to the creativity of legal drafters, working out how to set up institutions that would long outlast any individual human life.